Hey everyone, it's Rob Ryder. It's July 13th, 2012, late at night. We're going to look at a case that just happened uh, or just came out of the appeals court in Ohio and talk about what happened here. But this is the original complaint, 2010 12 7967. And it's just a complaint for money and foreclosure, but it's got some ramifications to it. Let's take a quick look at something here. So first of all, this is the original complaint, and then this is the appeals case that just happened June 27th, 2012. And I'm going to show you how to find those, so not too hard to find. If you go to Summit County, Ohio at this particular link, or cut and paste it, whatever you need to do, you can look at all their court records. You can look at every document that was submitted into a court case, or so it appears, and at least for these you can. So the appeals court, the name is Haydu, there's the case number, and of all the interesting things that could be said, this is the one that is really going to be the downfall of all mortgages, because it said in paragraph 14, moreover, in its complaint, Third Federal set forth a claim for foreclosure pursuant to the terms of the mortgage, which it attached to the complaint. In regard to the mortgage, Third Federal did allege in its complaint that it had complied with all conditions precedent under the terms of the mortgage. However, when reviewing the mortgage attached to the complaint, it incorporates by reference the terms of master mortgage. Master mortgage. And references the master mortgage's recorded instrument number, but no copy of the master mortgage is attached. For review of the mortgage attached, we cannot discern the conditions precedent to commencement of the foreclosure action. Thus, based upon the allegations of compliance with conditions precedent, we can only presume that these conditions are set forth in the master mortgage, which was not attached to the complaint, in contravention of some Civil Rule 10D. Under these circumstances, we conclude that the material question of fact existed as to the terms set forth in the master mortgage, and as the affidavit in support of the motion for summary judgment did not supply the missing terms of the mortgage or incorporate a copy of the master mortgage, Third Federal failed to meet its initial Drescher burden of establishing the absence of question of material fact of issue, or on the issue. A lot of talk about a thing called a master mortgage is what it's coming down to. And the master form mortgage they're talking about is the first lien. Your deed of trust mortgage that you have in your property file is actually a first lien security instrument. It's not the lien, it's a security for the lien. The first lien is this thing called a master form mortgage. And if you go to this Fannie Mae site that I have on there, you'll find some evidence of this, where for security instruments, first lien security instruments. And then there's these things down here called the master short forms for particular states. Now, not all states use this system, but hey, we'll take what we can get and we'll figure the rest of them out. But Ohio does, and that's where this case came out of. They use a master form mortgage. So in the complaint, they're talking about this master form mortgage. So let's go look and see what they put on the complaint. And again, you guys can read all this stuff at your leisure. But on the complaint, if we go down to page 8 of the complaint, it says at the top, master mortgage form. Now, this is the only piece of paper that has that at the top of it in this complaint. And as you can see, It says the master mortgage form recorded on 4/19/04 pursuant to some codes in the county, instrument number, but it doesn't have a book page or by. And since those are blank, it's never been recorded. So it's never been lawfully recorded. And that's what they're talking about here. And so at the top of this page for Fannie Mae, right, again, these are all first lien security instruments. Every state has one. So the thing you have in your property file is a first lien security instrument. What you want them to show you is the first lien. And in the master form states that use that process of the master form, of which there are these, they're really specific on what they have to do. And in the state of Ohio, where this is from, it would have to have this title page on it. And this is what it will look like. Looks like this. And it says everything in the box is the important stuff. The master mortgage form recorded by, and there has to be the name of a person in there. Can't put a bank in there. It says name of person. On behalf of, and then the name of the lending institution needs to be in there. And then this master mortgage form is being recorded pursuant to Ohio Revised Code 5302-15, 2006. When you go look that up, it'll also reference 16 in it. And in those two statutes, it says this form must be recorded before any deeds of trust, first lien security instruments, these up here, can be issued. And so for Ohio, the mortgage is going to look something like this. And it's just a standard mortgage form, and they can't, but the important thing is they can't issue that until this has been recorded. And they say themselves that it has never been recorded. There's no book or page. We found down in Florida also that most of these aren't recorded. Recorded means to be recorded. And in every case, on every state that uses this system, it will have the codes that say how it has to be recorded. So you have the evidence of their own laws that say what has to happen before they can issue any first lien security instruments, or they can issue any of these, and for them to be valid, this has to have been recorded in these particular states. Ohio's one of them. Okay, so if it isn't, then there is no first lien. Therefore, you're paying on a false obligation, which is Title 18 U.S.C. 514, the Criminal Code, Federal Criminal Code. And just for good measure, it's contempt of court to sue in the name of a fictitious plaintiff, Black's Law Fifth, and others. So if you're in a foreclosure, you can do anything else you want. I really can't tell you how to do this stuff, right? But I'd file a motion for an emergency hearing to point out this contempt and criminal activity under the seal of the notary. Right? So you're going to, whatever your motion is, you go do it, and you put down there that, basically you swear and affirm the best of your knowledge that this is true. You're not saying it is true. You believe it to be true. So and then you have a notary seal it, and that way it's a court record. I would even get the certificate of authority for the notary. That's just the way I am, right? The idea is you can make it a public record, and Lord Coke said back in the 16th century that if you have the ability to bring in the best evidence and you don't, the case should be heard against you. That's the way their system works. And you have the ability to bring in the best evidence because you can make a public record, full faith and credit of the Constitution. So, you need to put seals on your paperwork. It's very important. They don't. Here, look at look at this complaint. Let's go back to page, I think it's page 4, right? Page 3. It's a 3-page complaint, right? They get done talking. Here's the attorney's signature, but there is no seal. He didn't say anything under oath. He's not making, there's nothing here even says that he believes this to be true. He's not gone under oath. Well, you can't do that, right? In law, plaintiff must appear in proper person, provide evidence under penalty of perjury to substantiate his claim. So the plaintiff has, whoever the plaintiff is, has to have done this complaint under oath. And it's not on there. Somebody tried this down in Ohio that Gene Keating's been working with, and Gene helped him write up an emergency hearing motion, and now they have one. And they've pointed out these defects in the law, and you're going to see that their attorneys are going to go to jail. They have brought fraud into the court because they're claiming that you owe this, right? They're claiming that you owe that money on a false obligation for the very simple matter. This is so simple. It's just, you're going to have to wrap your head around this. They're going to provide the frickin' evidence. The master mortgage has not been recorded. If it's not been recorded, you can't write any frickin' deed of trust off it. Therefore, all those securities come back to you. Everything that you've paid, plus 3 times damages. So, those of you that are much smarter about putting paperwork into court than I am, please look at this, because this is what they don't have. They don't have the master form mortgage, or master mortgage form, or whatever the hell they want to call it, not recorded. They're providing the evidence themselves. Once this is entered into the court record, it's public record. And public record says it's not been recorded. They're giving you the evidence. Use it on them. So this is a real short one. That's all I really wanted to get out, because I know that a lot of people might be able to use this if they would just go put in the right motion. And I'm not the guy to ask about doing motions. I don't do any court paperwork. But if you're in a case, ask them how you put one in. My point is, do it under the seal of a notary when you're done. That way they have to see it when you put it in the court record. And have them put the file stamp on the back. That's one last thing here. I think it's really important. When I was talking to Tom here a bit ago, he was saying when one of his buddies was in with this paperwork we've been doing, as the judge was getting ready for the court case and talking, he was looking at the documents and flipping it over and looking at the back. At the back. Even the guy's certificate of live birth that he had recorded, and he was looking at the back. They're looking for a seal. And by definition, for the word file, when it comes to the clerk of a court, they're supposed to endorse the document with their file stamp. And again, endorse means the back. So if they put the file stamp on the side with the writing, they're saying that's the back of the paper. And what does the judge see? He doesn't see anything, because, that's the game they play. I just think, people talk about putting stamps in the back and signing them across and thumbprints, all that kind of stuff. Yeah, I can see where you'd do that. But, if you put a notary seal on there and say that you left this page blank intentionally, maybe that makes them keep an eye on the front. Or tell the clerk, I want you to put your file stamp on the back side and question her. Go look the definition up yourself and take it in and say, look, it says here you're supposed to endorse the document with your file stamp. That would mean it's the back of the paper. And have them go get a ruling at law. So, okay, that's really all I had. It's really that simple. Make the right argument. Point out the defect in due process of law, and quit arguing the facts.